Splat! Someone tosses a tomato and a beautiful sign is ruined. But is it really ruined? A Michigan dry cleaner thought his sign was and found himself in court. Walker and Company versus Harrison tells his tale. Herbert Harrison owned a dry cleaning business. He rented a neon sign with a clock and flashing lamps from Walker and Company. The rental agreement provided that Harrison would pay a monthly rent for a lease term of 36 months. Walker would be responsible for maintaining and cleaning the sign to keep it in first-class advertising condition. At the end of the lease period, ownership of the sign would pass to Harrison. Walker installed the sign in July. Harrison paid the first month's rent at the beginning of September. Then someone threw a tomato at the sign. Harrison complained to Walker several times, demanding that Walker come clean the sign. Walker didn't appear. In early October, Harrison sent a telegram saying that he thought Walker had violated the terms of the rental agreement and informing Walker that he was done paying rent. Walker came to clean the sign a week after receiving Harrison's telegram, about 2 months after the tomato appeared. Walker then sent Harrison a letter informing him that if he didn't pay his rent, Walker would sue for the collection of the entire balance due under the completed contract as provided in the rental agreement. Harrison didn't pay, so Walker sued. The trial court found Harrison in breach of the agreement and awarded Walker about $5,200. Harrison appealed.